Good evening. My group and I will be presenting the topic of Indigenous and Northern Affairs Canada. For the sake of the presentation, we will address this agency as INACT. The reason my group and I have decided to address and dissect the INACT is because more often than not, Indigenous communities throughout Canada continue to be ignored by the courts, unheard by the public eye, and Indigenous communities continue to lack resources in order to take care of their communal affairs in a proper procedural manner. As of August 2017, INACT has divided into two subcategories, so two new structures. One being the Crown Indigenous Relations in Northern Affairs Canada, the second being Indigenous Services Canada, which will be later on discussed throughout our presentation. The issues we have chosen to address lies in the effectiveness and the efficiency of these administrative organizations. Although INACT has been put in place to build a relationship between the Canadian government and First Nations, as well as address issues in Indigenous communities, their progressiveness has been a time-consuming and often inconclusive process. Throughout the presentation, we will demonstrate ways in which the INACT has failed in its duty to consult and negotiate with First Nation communities. The INACT has also failed to create a strong, long-lasting relationship between the Canadian government and Aboriginal communities as promised in its initial legislation in 1966. We will later demonstrate our solution to this problem. In short, the solution would be to establish a stronger relationship between the Canadian government and the Aboriginal First Nation communities, all in the hopes of creating a stronger relationship and stronger relationship ties. The solution of our problem we have chosen to address is inspired by the Red Hill Valley Parkway project. In short, the Red Hill Valley project demonstrates how transparency, openness, and cooperation between First Nations and the Canadian government could result in a healthy, long-lasting relationship between both parties.
The Indigenous and Northern Affairs Canada organization is one that focuses on the relationship between the Indigenous people of Canada, the Métis, and the Inuit with regards to the federal government of Canada. Before going into the relationship between the two parties and the pros and cons that come with it, we must first understand the brief history of the INACT itself. Established in 1966 with its headquarters in Gatineau, Quebec, the organization itself bases substance in the Indian Act of 1876. The Indian Act was overlooked by the Indian Affairs Department, which basically took the legislation in the jurisdiction of the First Peoples from the provincial government and brought it to the federal government itself. Fast forward to 2017, as of August, the INACT was actually dissolved into two parts. The first part itself is the Crown Indigenous Relations of Northern Affairs Canada. This organization itself looks a lot like the INACT itself, where it overlooks relations between the First People, the Métis, the Inuit, with relations to the Canadian government. It'll overlook relations in the Indigenous peoples and communities, as well as treaties and agreements, Northern Affairs and Arctic policy framework, exploring new ways of working together with the First Peoples, new permanent bilateral mechanisms, agreements and treaties, since 2016, consultations, as well as a national inquiry into mission murdering Indigenous women. The second level of this new INACT is the Indigenous Services of Canada. This section will actually look at the quality of life and the bettering of the First Peoples in the country of Canada. Looking back at what they look at is Indigenous health, anything that is basically related to policies with social and health, as well as education. Water to First Nations communities, as well as First Nation housing, First Nation infrastructure, social programs, as well as consultations, emergency management.
So the jurisdiction of the INAC is rather wide. Obviously, the issue of Indigenous relations in Canada is quite vast. So it administers many pieces of legislation, most of which are either meant to foster growth or independence. It also represents the government in land claim and self-government agreements. Now, through this mandate, the INAC has helped to provide us some autonomy with some of the nations in Canada, and the acts especially help provide a space for economic growth. Now, part of their mandate is also to promote this idea of the duty to consult, but we'll talk about that in a bit. So one example of success that the INAC had in fulfilling its mandate happened with the Wee-Wai-Kai Nation in British Columbia. Now, this nation gained autonomy over its land code, and this was done through a piece of legislation that was administered through the INAC called the First Nations Land Management Act. So the nation had been quite reliant on fishing before, but when it became not so profitable to continue in that industry, they decided to go through new business avenues, and they gained control over their land code, and this actually helped them to create more fluid business practices. They wouldn't have to rely on government bureaucracy anymore to do business deals, so this really helped foster that space for economic growth, and it was through, again, a piece of legislation that was administered through the INAC. Now, one example of partial success that happened on the issue of consultation, engagement, and the duty to consult. That's what it's called in their mandate. Now, this is the duty that when a government is about to incur onto what is considered to be ancestral land for a certain nation, the nation usually requests that they're consulted before the government makes this action. Now, they haven't always succeeded in fulfilling this aspect of their mandate. They've had some successes, some partial successes, and some straight up failures. So one hard-won success that they had, it was almost a failure, was in 2007 when BC Hydro purchased the excess power gained from a dam that was built in 1950 on the Chaco River. Now the Carrier Sakani Nation claims this river as a part of their ancestral homeland. So of course they said that they were not consulted properly before the government went in and made this incursion and do this deal. So this case actually made it to the Supreme Court of Canada, and in the first hearing they were ruled against. The nation was ruled against. The two parties, BC Hydro and the company called Alcan, were ruled to have had to consult the nations before doing the deal. So they won initially, but the nation appealed the decision, and on the appeal they found that they actually should have respected the duty to consult, and they eventually won this case. So what began as a failure turned into eventually a success, but it was a hard-fought win. Now, an example of outright failure in regards to the INAC's ability to fulfill this element of their mandate, this element of promoting the duty to consult among the government, happened in 2018 in a Supreme Court ruling where the legislators decided that they did not have the duty where the Supreme Court decided that the legislators do not have the duty to consult with First Nations before introducing legislation that could impact their constitutionally protected treaty rights. So the issue was brought forth by the Mikisew Cree Nation in Alberta. They claimed that two omnibus budget bills from 2012 violated treaty rights. They claimed it threatened their ability to hunt, trap, and fish on this territory. And they claimed the government had the duty to consult with them about it before creating the pieces of legislation. The Supreme Court ruled against them 7-2, saying that the legislators do not have a duty to consult. They said that it would slow down the legislative process and create a situation of too much oversight from the judicial into the legislative branch. So here's just a quote from the Supreme Court Justice Andromake Karakatsanis, who said that applying the duty to consult doctrine during the lawmaking process would lead to significant judicial incursion into the workings of the legislature. So this is one example where the INAC failed to uphold their mandate to protect this idea of the duty to consult between the Canadian government and First Nations.
The Enact's failure to uphold government's duty to consult First Nation communities prior to introducing new legislation has become a reoccurring issue. This issue, amongst many, is resulting in the hostility and distrust between First Nation people and the Canadian government. Consultation has become one of the largest challenges that the Enact has been facing. Coordination is lacking amongst federal, provincial, and territorial government. That is why we believe that the success of the Enact relies heavily on establishing stronger and effective relationships between First Nation communities and the local government. Building these partnerships at a local level will allow for successful relationships to foster at a federal level. The importance of how local authority deals with these Aboriginal issues within their jurisdiction can influence the role of the Enact throughout Canadian society as a whole. The Red Hill Valley Parkway project in Hamilton provides a good example of how the government's duty to consult with the First Nation communities led to the start of a new, strong, and effective relationship. When the government of Ontario wanted to build a highway that would essentially extend through two First Nation communities, the local government informed them. Though the Supreme Court of Canada declares that Ottawa has no duty to consult with the First Nation communities before implementing legislation. The local government's decision to act and notify the First Nations communities about the new product allowed for clarity and transparency. The recognition of the duty to consult First Nation communities by the government on this matter led to successful negotiations on both sides. We can see how the importance of agreements between the First Nation communities and municipal governments shapes social and cultural well-being. The Enact's goal is to work together to make Canada a better place for Indigenous and Northern peoples. As a result, we propose 3 factors that can achieve this goal. The Enact must firstly engage in jurisdictional negotiations. Agreements to form a contract to buy services such as snow removal or trash collection from a municipality. Access to water rights in forms of treaty or legislation. Secondly, relationship building. Deepening ties between communities and their governance allows for Indigenous and a local authority to engage in intergovernmental dialogue and formal relationships. Lastly, decolonization. Commitment to build equal and respectful relationships between local and regional Indigenous authorities. The quality of the relationship with First Nation communities will be measured by the effect invested and the integrity of this agency. You have to realize why it is so crucial that respectful relationship is fundamental success to any partnership.
As mentioned above, the relationship between Indigenous people and the Canadian government is constantly improving thanks to the Enact. There has been a recognizable effort by the government to consult with Indigenous people when taking decisions. The maintenance of a trusting relationship between both parties will be essential to assure for a positive future. The important issue that will also need to be addressed is the rights of Indigenous, Métis, and Aboriginal people living officers, meaning non-status Indians. Prior to the Federal Court of Appeal decision in 2014 to make the federal government now accountable for non-status Indians, they were denied many of the rights that were offered to status Indians under Section 91, Article 24 of our Constitution. They are now granted the same rights and the same privileges, such as having a better and the same healthcare, education, and not having to pay certain taxes. Furthermore, in February 2018, Prime Minister Justin Trudeau made a promise in the House of Commons, in a very emotional speech, to initiate a new legal framework for Indigenous people. He was basically referring to the Constitution of 1982, more specifically Section 35. Therefore, the Enact will have to make sure that this promise is kept and that decision keeps moving forward to assure for a positive future for the better.
In conclusion, throughout the years, the INAC has demonstrated its success through the development of nations such as the Wee-Waukee Nation in British Columbia. However, as seen through our presentation, the INAC did not always fulfill its duty to consult with Indigenous communities and participate in negotiations with such communities. This is demonstrated through the BC Hydro purchase and the decision made by the Supreme Court of Canada in 2018. As we have seen throughout our presentation, the post-division of the INAC and its 2 subcategories continue to ignore their duty in maintaining a strong, long-lasting relationship between the federal government and the Indigenous communities of Canada. The discussion of the Red Hill Valley Parkway project in Hamilton highlights the importance of consultation with Indigenous communities prior to introducing legislation that may affect their communities. Having the government take an extra step to introduce legislation, communicate with these First Nations peoples, and talk to them and make them feel like they are part of someone's community is very important and demonstrates how openness, transparency, and just having the community feel like they are a part of Canada really helps strengthen the relationship between both the Canadian government and the Indigenous communities of Canada. Thank you for watching our presentation. Hope you enjoyed it.